policing is a most noble profession. It is. It is. And to be very clear, this case is called the State of Minnesota versus Derek Chauvin. This case is not called the State of Minnesota versus the police. It is not. Policing is a noble profession, and it is a profession. You met several Minneapolis police officers during this trial. You met them. They took the stand. They testified. Make no mistake, this is not a prosecution of the police. It is a prosecution of the defendant. And there's nothing worse for good police than a bad police who doesn't follow the rules, who doesn't follow procedure, who doesn't follow training, who ignores the policies of the department, the motto of the department: to protect with courage, to serve with compassion.
That was Steve Slisher, prosecutor, closing arguments. Let me welcome to the show someone who has been, if you're not following her, then you're missing out on a lot of the nuances and intricacies of this case. Angi with an I. Let me welcome her to the show. Professor, Minnesota, University of Minnesota, law professor and attorney extraordinaire, Professor Angi Porter. Welcome back.
Thanks for having me back, Professor Hunter.
Good to see you. Good to see you. And you can follow her at Angi with an I, Marissa, Mary SSY. All right. They played the 9 minutes and 29 seconds again. Did they? Because Sarah Sidner was like, and I had to get ready for my show, but I saw her tweet, roughly before I came on. She was like, I cannot watch this again.
So actually the state, they walked through it at certain points. They didn't just play it straight through, which I thought was a good call on their part. They focused in on very specific points to show that Chauvin disregarded human life and, really focused on Chauvin's conduct. So I thought that was a good strategic move on their part.
Okay. And Steve Slisher's, this is not the state versus the police, it's the state versus Derek Chauvin. I thought at the beginning when I saw the police chief was testifying for the prosecution that they were going to make him kind of this lone wolf, this outlier, this guy that does not represent the system, that does not represent policing, and they were going to throw him under the bus, which it looks like that was the whole rap. Did you see that?
You're absolutely right. And honestly, that was the part that I kind of cringed about when I was watching Schlischer's closing. Now, to be clear, I thought his closing was brilliant. I thought it was the best that he could have done. But you and I talked about this already, Professor Hunter, in previous weeks. We knew they were going to go with the bad apple theory. We know that theory is a fiction. Perhaps they are true believers in it, but we knew that that's what they were going to do. And honestly, I think that's what they have to do under the law to secure a win in this trial.
And he kept with, this was, he knew better. He just didn't do better. Yeah. In your custody, in your care, something that when we first met was a refrain that started the opening statement from the prosecutor, and it made its way throughout the trial, and it was one of the mantras in the closing: in your custody, in your care. He knew better. He just didn't do better. I believe, again, there's going to be a conviction, but during this trial we saw another killing. So the system is on trial. I'm sorry, there's just no way around it. And they have another trial coming up in August, I believe. The other 3 officers will be on trial. Mm-hmm. So how do they make that pivot from this bad apple to these other 3?
Exactly. Well, they do it by dealing with discrete, separate juries who live in their own little world, which is the trial, who don't really think about connecting those dots. And they try to use that to their advantage. But of course, all of us watching know the truth, which is just what you put your finger on. If it's one bad apple, why do we have 4 bad apples here? How did they all act in concert? Why do we have multiple police shootings happening every time we look up? I mean, it's not one bad apple. We know it's a systemic issue, but they can't, the law is not competent to address that. And that's another conversation, a conversation we all should be having about the legal system and how it is inadequate, grossly inadequate to address the issues that we face as Black people in this country.
All right. So for people who did not watch today's closing arguments, give us the Cliff Note version of what happened today, and then what's going to happen next.
Yeah. So right now we're in a break situation. So I'll start there. We're on the jury's 30-minute lunch break, which should be over in maybe the next 5 or 6 minutes here. So that to me is a little unprecedented. The judge actually interrupted Eric Nelson's closing argument, which was the second argument today, which went about 2 hours and 30 minutes long. Yes. So I'll come back to that, Professor Hunter. But the first closing was done by Steve Schlischer. It was about 1 hour and 45 minutes long. But the difference with Schlischer, or Schlish, as I like to call him, he kept your attention. So he did what an attorney should do during closing arguments, used expressiveness in his facial expressions, used colorful language to describe what happened. He didn't just say Derek Chauvin put his knee on George Floyd's neck. He said he grinded his knee. He twisted his arm. You know, he's being really descriptive because he wants to use this chance to make the jury really connect the dots. And he does not want them to be desensitized. So I think that's another reason they didn't just play that video through. Another masterful thing that Schlischer did, which is expected on closing arguments, is he looked at the law and told the jury exactly what to do with the law. He broke down each of these 3 crimes into its elements, even showed a nice slick chart breaking it down and walks them through. He's essentially putting his voice in the jury room saying, this is how you need to deliberate. Start with second-degree murder. Let's go through all the elements together right now. And he did that. And he told them exactly which pieces of evidence to think about when they're assessing each element. Masterfully done. And you know, the indignation was there. You almost felt like this was personal for Steve Schlischer. That's the type of drama he brought to this. Now, trial is a performance. I can't stress that enough. But if I had to rate these 2 attorneys who have spoken so far in terms of their acting skills, in terms of their ability to emote, Steve Schlischer is the winner here because he really dug in and talked about how heinous this was and asked questions. Where was the resistance? He said. He was just baffled at all of the arguments that he picked through and dismissed methodically. And he ended by saying, this was not policing, this was murder. Clear, straightforward, unequivocal. At the end of that closing, the jury, they were clear. Now, you and I have also talked about the volley of trial. So Eric Nelson got up there, started his 2.5-hour tirade, which is still going, which will continue.
2.5-hour rebuttal.
Yes, which will continue in about 5 minutes.
Could this backfire? Because I have a short attention span. Let me just be clear for everybody in the back. I can't sit. I walked out of a Harry Potter movie because it was too long. I was like, I read the book. Y'all, what y'all not going to do is take up another hour of my time. I done read the book. I know how this ends. I'm out. I can't imagine being trapped in a jury box and this man is going off for 2.5 hours.
This can absolutely backfire. Absolutely. And I'm actually surprised there weren't 2-hour time limits. Usually, you know, at trial, there is a time limit for closing arguments. Maybe it was 3 hours. I don't know. But at a point, you're working on diminishing returns, right? Because the jury, especially if they're hungry, they're looking at you like, you're standing between me and lunch, which is happening at 2:30 p.m. Central Time here. And he just created a mess, just created a whirlwind of confusion. In fact, he even misstated the law a little bit when he summarized the jury instructions related to cause of death, related to intent. I mean, he's just obfuscating and creating doubt in that way. Also, he did a couple of the classic lawyer missteps on closing, which was to start with pleasantries. Thank you for being here. I'm going to take a while. You know, when you lead with, I'm going to take a while, people already shut their brain off. They're like, all right, well, guess I'm going to be here sitting for a while listening to you so I can think about lunch or I can think about whatever. So, you know, already did some classic missteps. Went too long. But I don't want to underestimate the power of a defense closing. Creating confusion, even if that means misstating some of the law, bringing in all kinds of theories, introducing doubt by focusing on irrelevant inconsistencies, all of that can be effective, especially if you have one juror, two jurors, three, who are looking for something to hang their hat on, because when they see Derek Chauvin, who took his mask off, by the way, during that argument, so we can see his whole face. When they look over and see him, they might see their uncle, they might see their father, their brother, their ideal version of what a human being should look like. And so if they're looking for ways to let him off scot-free, all of that confusion, that flurry is helpful for them. It's helpful for them.
Okay. Professor Angie Porter, she's here. ANGI Porter. You can follow her at Angie Marissa, MARYSSA. Now what happens? Okay, he comes back, more SHIT from him. And he's going to throw it at people, throw it against the wall. He may go another hour, maybe another 2 hours. I don't know. When he's finished, and I believe you think he'll be finished today?
I hope so. I would think the judge would stop him again. So yes, he is actually back up. I have him on my other screen over here, probably continuing to talk. He ended on the drugs, his favorite topic, before you and I started talking. So he's probably going to spend some more time there. Once he sits down, the judge promised that he would be giving 20-minute breaks between each of these arguments. They just took a 30-minute break, so I'm not sure. But then Jerry Blackwell will get up. At least this is what I have heard. Word on the street is that Jerry Blackwell is doing the prosecution's rebuttal argument. So he'll get up and hopefully.
And Jerry Blackwell was the one that did the opening statement?
Yes, he was, the Black attorney, one of the founders of Minnesota Association of Black Lawyers, in fact. He will hopefully detangle the hot mess that Eric Nelson created over the last couple hours plus, and reassert to the jury what Steve Schlischer told them, which was very clear. Don't get distracted. This was murder. This was second-degree murder, third-degree murder, and second-degree manslaughter. Don't get distracted.
All of it. It was all of it.
Oh, yeah, all. Oh, yes, he was very clear. It's all. So they will hopefully keep it concise and simple and straightforward. Sometimes entertaining ridiculous argument gives it life. So I hope that Blackwell will just take maybe the most salient of points and reaffirm. And then he'll sit down, and then the judge will reiterate some of the jury instructions that he started the day with. The jury has little packets of those instructions, and they will go off to a hotel where they're being sequestered for however long it takes for them to deliberate.
Now today is Monday.
Mm-hmm.
It's Monday. It's 3:47 p.m. Eastern time. Here it's 2:47 p.m. there in Minnesota, Minneapolis. How long do you think if all this happens today? your
Uh,
experience?
it's so hard to predict juries, Professor Hunter. People might be predicting out here, but I look at that as a shot in the dark, honestly.
Okay. All right.
Um,
And I put you,
yeah,
listen, let me respect that,
yeah,
because this has to not be the era of folk giving opinions out of thin whole cloth and dingleberries. That's what I say.
out
They
of
just
thin
be
air.
pulling it off of dingleberries and throwing them out there. And I respect that, because there's a lot of, if the jury's, they're taking a long time, then that means one thing. If they come back quick, that means another thing. Because folks need to feel like they know stuff. But
Right.
we're in a particular time, and I was talking before you got here about the strangeness of the time that we're in. And I know racism has been here since before Columbus. No, there wasn't any racism before Columbus. Who am I fooling? Anyway, but when we got here in quote unquote 1619, of course, Black people were here before, but in bondage, there
Right.
was a willful denigration of our humanity, and it goes to value, which is a strange thing. And now we find ourselves in this space where people are no longer willing to be devalued, to not be seen and heard. They are not having it. People are in these streets right now, on the heels of yet another killing during this trial and all the mass shootings that are going on. There's something going on in this country.
Yeah.
Probably in this world. I don't live anyplace else, so I'm not sure. But it's different. These aren't the OJ times
Right.
when things were on fire. These aren't the Martin Luther King times when things were on fire. These times are different. And I don't know what's going to come of it, but I know we're at an inflection point that we can never return from. So I don't know how we go forward is my ultimate statement.
That is worth pointing out. That is worth pointing out. There are different things going on. And last week, Eric Nelson sought to sequester the jurors and re-question them because of the killing of Dante Wright. And the judge said no. So, these jurors could be thinking about that. Classic illustration of how the times are different. Um, I will say, there were a lot of witnesses and there was a lot of evidence in this trial. And so, from a basal level, you sort of expect the jury to take their time going through each of those things. Now, how they decide to deliberate is up to them. But you get 12 people in a room, they're probably going to decide we're going to do some sort of process given the magnitude of this case. So I could see them working their way through each witness, and that takes time.
How many Black women do we know?
We know, I think 1 Black woman, 2 biracial women, 3 Black men.
Do we know the age of that one Black woman?
She, I think, was 61 in her 60s.
Okay.
Actually,
All
I
right.
don't
Let me
even
just
know
say
the
this. Let me say, you just need 1 Black woman of a certain age to gather up that whole jury. That actually gives me comfort. You said 61, a 61-year-old Black woman.
Snatch
I
up
wish
the jury.
somebody would.
Yeah.
Just saying.
And I mean, her, juror B52, I've been calling him. I think there are a couple of people who will at least put some structure in place so that if somebody's trying to wiggle out of that, they're going to hold them to account. But the longer we go, so if we're going into next week and longer, the more worry we start to have about the jury being deadlocked. But again, you just really can't tell. You can't tell what they're doing in there. And it's a group of 12 people talking. So
your last case that you presided over, and you're teaching this now, right? And I'm imagining, I was just talking to one of your mentors this past week, and he was saying you're creating curriculum around African centric law and how we should be looking at the law, which hasn't happened, which is shocking that there's no rubric for this. You're creating it. So I just want to thank you. But what's that work?
yeah, well, I'm sure it is happening somewhere across the diaspora and the continent. People are having discussions, but I will say in the Western Legal Academy, I think it's safe to say this is a new way of thinking. in law, when we talk about race, so often we're centering whiteness and really thinking about how Western law has impacted Black people or how Black people have impacted Western law or European law. But we're not talking about our own indigenous systems of governance and ways of knowing how to govern ourselves. And the fact that our ancestors brought those ways of knowing with them to this hemisphere. And they didn't just disappear, just like all of our ways of knowing. They continued in our minds. They were passed down generation to generation. And so that's what I'm really trying to study and teach. And hopefully by restoring and reconstructing and re-examining our own ways of knowing law, we can derive some usable truths. I think that was Anderson Thompson who said that, to help us in this current time, to help us think differently. You know, in this system of law, when we say jury of our peers, we know that that doesn't apply to us. We know, as Dr. Carr always says, the United States is not a real nation of people. Eric Nelson is not in the same community. He doesn't have a special affinity towards George Floyd. He's speaking in coded racial language. His arguments are littered with racist tropes. And so can we imagine a system where we all truly are joined in community with one another? That system existed across Africa at once upon a time, before enslavement, before colonialism, imperialism. So we need to rediscover that.